Good evening. I was just getting set up to record, going through one of the deposition transcripts, and I was torn between Blake Lively and Colleen Hoover and Lizzie Talbot, the intimacy coordinator. Then I had a notification pop up, so I went to go and check it out. So I did a video a few weeks ago because I cover all the kind of side cases that are attached to this main case. And I did a video a few weeks ago. Andy, Popcorn Planet, they have filed a motion for a review of the order denying the motion to quash. And I did my video of their motion a few weeks ago when it dropped. We now have Blake Lively's response to that. So I was going to go through that. There are some attachments with it. There's about 5 attachments with it. I think all but one are court transcripts of various hearings. They are extremely long, in the sort of 50 to 70 pages at least each. So I'm not going to go through all of them. There is one attachment which is quite short, I guess, which is some messages. I'll just have a look at them, but I want to go through this response. Okay, so this is Blake Lively's response to Popcorn Planet. Let me just make this a little bit bigger. I do not have my reading glasses on. Okay, introduction. In an 18-page, well-reasoned and thorough opinion entered after holding 4 hearings, the Honourable Magistrate Judge Lindsay Griffin exercised her broad discretion and correctly ordered Popcorn Planet to produce hundreds of pages of admittedly relevant and responsive text messages it is withholding based on improper assertions of Florida's statutory reporter privilege and the state and federal common law privilege. Judge Griffin rightly denied the motion to quash on multiple independent grounds. 1. Popcorn Planet waived the right to assert reporter privileges. 2. Even without a waiver, Miss Lively's need for the information overcame any assertion of them. And 3. Popcorn Planet failed to demonstrate it was entitled to assert them. Judge Griffin also correctly held Popcorn Planet did not show undue burden. Popcorn Planet adopts a kitchen sink approach in its non-conforming objections, but fails to adduce a single colorable argument that any one of the independent grounds for denying the motion to quash, let alone all 3 of them, is clearly erroneous or an error of law. Legal standard. Okay. I won't go into that because without looking at the cases themselves. Oh, I don't know what. No, we'll do it. Okay. I'll just read what is here. A district court reviews a magistrate judge's ruling on a non-dispositive matters, which includes a motion to quash a third-party subpoena under clearly erroneous or contrary to law standard. A finding is clearly erroneous when the reviewing court on the entire evidence is left with the definite and firm conviction that a mistake has been committed and is contrary to law when it fails to apply or misapplies relevant statutes, case law, or rules of procedure. The clearly erroneous or contrary to law standard is extremely deferential, and magistrate judges are afforded broad discretion in issuing pre-trial orders relating to discovery. Okay, so the argument. Judge Griffin correctly determined Popcorn Planet waived the reporter privileges. Judge Griffin correctly held that Popcorn Planet waived the reporter privileges on 3 independent grounds. By 1, producing documents that bear no discernible substantive difference as compared to the withheld documents. 2, failing to timely provide any privilege log. And 3, submitting a privilege log with insufficient particularity to assess the privilege claim. Popcorn Planet does not contest that it waived the reporter privileges by producing certain documents. The court can and should adopt the R&R based solely on Judge Griffin's finding that Popcorn Planet waived the reporter privileges by producing to Miss Lively 7 communications that bear no discernible substantive difference to the documents it is withholding. Popcorn Planet's failure to object to Judge Griffin's waiver by production finding is fatal. Even if the argument were preserved, Popcorn Planet does not and cannot explain how it did not waive the reporter privileges by producing some, but not all of them, on the same topic. Okay. It is undisputed that Judge Griffin properly decided that Popcorn Planet waived the reporter's privilege by producing documents on the identical topic and with the identical sources as the ones they are attempting to shield from discovery. Popcorn Planet waived the reporter's privileges by failing to timely or sufficiently log withheld documents. Judge Griffin rightly found that Popcorn Planet waived the right to assert privilege first by failing to produce any privilege log, and then by providing ones that lacked sufficient information to assess the privilege despite repeated opportunities to do so. Okay. Popcorn Planet does not claim that Judge Griffin applied the wrong legal standard and fails to address or attempt to distinguish the binding 11th Circuit law and Rule 45 on which the R&R relies. Popcorn Planet also does not dispute that both the privilege logs fail to comply with Rule 45 by asserting vague and generalized conclusions that do not permit Miss Lively or the court to assess the claim of privilege. Instead, Popcorn Planet argues that individuals asserting the reporter privileges are exempt from producing privilege logs at all, and if they do, can rely on vague and blanket assertions. Objections at 10 to 11. Popcorn Planet's argument amounts to an improper attempt to rewrite the plain language of Rule 45, which does not carve out reporter privileges from its mandatory requirement that the withholding party describe the nature of the withheld information that will enable the parties to assess the claim. Whatever the weight, the handful of out-of-circuit cases Popcorn Planet cites deserves about whether a reporter can avoid a privilege log when moving to quash a subpoena in its entirety, they are irrelevant here, because Popcorn Planet ultimately produced some documents and therefore must provide a privilege log, even under the precedent it cites. Okay. Popcorn Planet wrongly argues that Judge Griffin's in-camera review foreclosed a finding of waiver. The only case it cites for the proposition, Nationwide, does not hold that a court can apply only one of the 4 remedies it raises, nor would such a rule align with the broad discretion courts have in remedying improper assertions of privilege, including by applying multiple remedies. Plus, the argument is irrelevant as to the final privilege log because Popcorn Planet produced it after the in-camera review. Judge Griffin did not err, and Popcorn Planet has failed to identify any aspect of the R&R's finding on waiver that is clearly erroneous or contrary to law. Okay. Judge Griffin correctly determined that Miss Lively overcame the reporter privileges. Popcorn Planet does not challenge and therefore concedes that Judge Griffin applied the correct legal standard when finding that Miss Lively overcame the qualified reporter privileges. Popcorn Planet also does not challenge Judge Griffin's determination based on her in-camera review of the documents listed on its initial privilege log, that the responsive materials are directly relevant and material to and go to the heart of Miss Lively's claims. The only objection that Popcorn Planet mounts to the finding that Miss Lively overcame the privilege is that Section 90.5015, subsection 3, requires an evidentiary hearing, and that there is a lack of evidence demonstrating that the information the subpoena seeks was otherwise unavailable. Neither argument is correct, let alone demonstrates that the R&R was clearly erroneous or contrary to law. First, Section 90.5015, subsection 3 requires only that a court support a finding that the statutory privilege is overcome with clear and specific findings made after a hearing. Popcorn Planet's attempt to insert the word evidentiary into the statutory privilege is contrary to its plain text and would violate the necessary presumption that the legislator said what it meant and meant what it said. Judge Griffin went beyond the requirements of Section 90.5015, subsection 3, by holding multiple hearings before entering the R&R. Second, Popcorn Planet's assertion that there is no evidentiary support for finding that Ms. Lively tried to discover this information from the defendants and to some extent has been unable to obtain these materials from them is belied by the very findings of which Popcorn Planet asked the court to take judicial notice. These filings reflect, inter alia, Ms. Lively served requests for productions on the Wayfarer defendants in February 2025, targeting communications with any media outlet of any kind and any social media accounts or influencers or other individuals who maintain a public online presence, and about efforts to seed, influence, manipulate, boost, amplify, or engage with social media. Subsequent RFPs requested all communications with content creators, specifically naming Popcorn Planet's owner and founder Andy Signal. On July 15, 2025, the underlying court ordered the completion of all outstanding party document productions by July 25, 2025. In late July 2025, Ms. Lively served deficiency letters on the Wayfarer parties, including to address the fact that they had not produced a single responsive communication with content creators or reporters. For example, one deficiency letter to defendant Tag, a crisis communications firm that admitted in sworn interrogatory responses that Mr. Signal seeded, generated, created, or influenced social media content, or provided related digital or social media services directly or indirectly at the request of or on behalf of any Wayfarer party or their agents or affiliates, confirmed that Tag still had not produced communications with content creators and reporters concerning statements made about the actions, despite those creators and reporters sharing in their outlets and on their social media profiles what appeared to be statements directly shared by Tag. Interesting. The letter continued. By way of Andy Signal recently shared what appears to be a Google document link containing a statement from Mr. Friedman that the Tag defendants have not produced. In early August 2025, Ms. Lively filed a motion to compel the Wayfarer defendants, including to produce communications with content creators, which the court granted in late August by September 2nd. By late September, Ms. Lively was continuing to file motions relating to the Wayfarer party's failure to fully comply with discovery, including relating to communications. As explained during the first hearing before Judge Griffin on October 22, 2025, Ms. Lively filed a motion for spoliation relating to the Wayfarer defendants' failure to preserve Signal communications, which they admitted to using to communicate with content creators that same day. As to the handful of communications with Mr. Signal that the Wayfarer defendants produced, Ms. Lively's counsel explained to the court that there was no assurance that their production was complete, given the history of failing to preserve and to produce responsive materials. Okay. In sum, there is nothing clearly erroneous about Judge Griffin's finding that the record contains sufficient evidence that the information sought with the subpoena was unavailable. Finding otherwise would amount to sanctioning an impermissible shell game, whereby a party and third party can deprive a plaintiff of admittedly relevant central material and responsive information simply by running out the clock on discovery. It's interesting to see, I will just comment this, it is interesting to see Lively saying, well, look, I have to say this, right? Wayfarer obviously did categorically deny that they deliberately set their signal messaging to auto delete or anything of the kind. But it's interesting to see Lively unhappy that, people are maybe using tactics to avoid, having to produce discovery. Especially when we consider this in light of Van Zandt. Okay. Judge Griffin correctly determined the reporter privileges do not apply to Popcorn Planet. Judge Griffin correctly held that Popcorn Planet is not entitled to assert Florida's statutory privilege by failing to demonstrate that Mr. Signal is a salaried employee or independent contractor for one of the covered entities. To the contrary, Popcorn Planet admitted that Mr. Signal is self-employed and pays himself from the entity that he founded, owns, and operates, which is clearly not contemplated in the statutory definition of a professional journalist. Implicitly conceding it failed to address a requirement of the statutory privilege, Popcorn Planet now argues for the first time that it is part of a network by virtue of its use of YouTube. Leaving aside that this court cannot consider the argument because Popcorn Planet never made it to Judge Griffin, it again improperly depends on the rewriting a statute. The statutory privilege modifies network with the term radio or television, and Popcorn Planet concedes that it is not a radio or television network, which ends the inquiry. Judge Griffin's determination that Mr. Signal is not a salaried employee or independent contractor for any of the covered entities is amply supported. Popcorn Planet's argument that Judge Griffin's most fundamental error is a complete failure to analyse the First Amendment reporter's privilege ignores that courts in the 11th Circuit have found that the federal common law privilege and Florida's statutory privilege are virtually indistinguishable. To the extent that there is any daylight between who is entitled to assert the statutory versus common law privileges, Judge Griffin accounted for that possibility by holding that Mr. Signal does not bear any of the indicia of a professional journalist, which courts consider when determining the federal common law privilege applies. Even accepting as true that the reporter's privileges may apply to non-traditional journalists, Judge Griffin properly found that they do not apply to Mr. Signal. Judge Griffin correctly determined that the subpoenas did not impose any undue burden. Judge Griffin was right to find that Popcorn Planet failed to substantiate any undue burden, including by stating that there was no problem with the scope of the subpoena during the first hearing, and because Miss Lively has unsuccessfully attempted to otherwise obtain the documents and need not exhaust those efforts before obtaining the information from Popcorn Planet. Conclusion. For the reasons detailed herein, Miss Lively respectfully asks the court to adopt Judge Griffin's R&R in full. And that is Sigrid McCauley. That is the same attorney. That's the same attorney they're framing as Blake Lively has just brought on the attorney who represented Epstein victims. When Sigrid McCauley, she has been working for the team the whole time. She was Leslie Sloan's attorney. So she is definitely not new to this, which is how they're framing it. They're just trying to make a link to the fact that she represented Epstein victims, which is not something that they boasted about when she was just Leslie Sloan's attorney. Anyway, so that's that. Is this the right one? Yes. Okay. All right. So this is the only exhibit I'm going to go through. So it's from Meryl Gavansky, another Lively attorney. Dear Judge Griffin, on behalf of respondent Blake Lively and pursuant to the order entered by Your Honour, please find attached the responsive documents received from counsel for Popcorn Planet this morning. There's a screenshot of a message dated 22nd of December 2024 from Andy. It's redacted who it's to. It's an interview request. My name's Andy Signal. I run a popular YouTube channel that covered the Blake Lively versus Justin he's put Baldini drama. Seeing the latest lawsuit and your name mentioned made me want to attempt to reach out and try to understand some insight as to what happened here. Would be happy to speak on or off the record. Thanks for your consideration, Andy Signal. And then we got emails from there on from the lovely little doll. I love Michelle. From the wonderful Michelle Moulton. So these are dated. Are they all dated the same? No, they are different dates. So this one is 28th of January 2025 to Jed Wallace. It's just letting them know that they've been doing coverage, and that they've got, that they're making content and would like to incorporate, if willing. Here's a link to the promo channel the promo trailer for our channel. Thanks so much for taking the time. Hope to hear from you, Michelle. The same message to Steve, I'm presuming it's going to be Steve Sarowitz on the 23rd of January. Same one to Jamie Heath. I'm assuming it's Jamie Heath. January 22nd. January 7th to Brian Friedman. Same message again. Stephanie, I'm guessing it's Stephanie Jones. So it wasn't just, it's not that like they were approaching the Wayfarer defendants, which is what Lively is saying is, well, Andy was working with the Wayfarer defendants to, as part of the retaliation. Well, no, they actually reached out to Stephanie Jones, who is not accused of being part of the retaliation. I think that's it. Is it it? No, they also reached out to Melissa Nathan. So I'm writing on behalf of, it's slightly different one. This one is. This is November 5th, 2025. I'm writing on behalf of YouTube channel Popcorn Planet. We've been doing extensive coverage of the. Hold on, that's a draft. Okay, so it's January 15th, 2025. Hi, Melissa. I'm writing on behalf of the YouTube channel Popcorn Planet. We've been doing extensive coverage of the Baldoni Lively suits and would love to speak with you by a Zoom interview. We previously had Shusty Flat on our channel on her interactions with Blake and how that interview went sour past. Would love to set something up for you. This is a promo for the channel. And that's that. And there is absolutely no evidence that anyone actually responded to any of these. Now, I'm not saying they didn't. I'm just saying in this exhibit, there is no evidence that any of these emails received a response. So, and they are exactly what Andy says they are. They are reaching out and, would you like to speak to us for an interview? Can you comment, or give us something? It's just like press inquiries, really. Okay. So, that's where we are. That's the update with Popcorn Planet docket. I'm still waiting for something on the Jed Wallace appeal. Nothing's been filed yet, but I will keep you updated if and when something does. Okay. I keep forgetting to say this in my videos as well. It would be a huge help if you haven't already, if you could like the video and any other video that you watch, and subscribe to the channel, and if the hype function is available, it all helps me and helps my channel. So Yeah, thanks guys for listening. And I will now continue with the huge amounts of unsealed documents.